Hi, welcome to this video on the General Data Protection Regulation 2016. It's a brief look at the changes to data protection law that will be coming into effect in May 2018. Before I start, just a brief recap of the current position, which dates back to 1995 and the EU Data Protection Directive, which was implemented in the UK by the Data Protection Act 1998. For anyone involved in marketing, also be familiar with the Privacy and Electronic Communication Regulations 2003, as they've been amended over time. So the new regulations coming into play with the aim of harmonising data protection across the whole of Europe so that European citizens will have the same rights no matter where they're based, and it will come into effect, as I say, 25th of May 2018, so that's the date for your diaries to make sure that you are compliant by then. With it coming into place across Europe, of course, the big question on everybody's lips is Brexit. Now, we're not expecting it to have a material effect. There is a new data protection bill that we're yet to see the text of, but it's expected that that will implement GDPR into UK law, and so we can carry on the basis of GDPR applying in the UK. Of course, it will also affect UK businesses that hold data on European subjects, because GDPR is not limited to businesses and organisations in member states. In terms of who the GDPR is going to affect, it's going to affect all organisations and businesses. There's no carve-outs for small businesses, so it will cover everything from big PLCs right down to sports clubs, church groups, one-man bands. All businesses are going to be affected by this, and it's going to apply to everyone. The big headline change is the increased fines. At the moment, fines are up to a maximum of £500,000, but from next May, that's going to be increased to €20 million or 4% of global turnover. And that's the big change that's hitting the headlines. So the obligations on data processors are new, because data processors at the moment don't have the direct obligation on them. Instead, that comes through the contractual documents with the data controller. But as from next May, they will be required to comply with the GDPR, or the new Data Protection Act, in terms of maintaining records of their processing activities. They'll also have a direct obligation to implement appropriate security measures over the personal data that they're processing. That could be things like technical measures, so putting in place firewalls, encryption, and that sort of things, but also organisational measures, so making sure that their staff understand the nature of the data and how to keep it private. There will be certain circumstances where data processors may be required to appoint a data protection officer. Data protection officer is a new post that's being created, a person who will be independent of the organisation in their role as DPO, and will be required to advise the company on data protection issues and also act as a liaison for the Information Commissioner's Office. In addition, data processors will need to comply with the international data transfer requirements. So this is where data is transferred outside of the EU and making sure that it receives the same level of protection as it would within the EU. The data protection officer, or the business, if there isn't a data protection officer appointed, will be required to cooperate with the ICO or any supervisory authority in terms of any investigations or dealing with breaches. Moving on to data controllers, so that's the people that are collecting the data and choosing how it's to be used. The big difference will be the accountability, and that is, in effect, data controllers being able to demonstrate compliance with the GDPR and the Data Protection Act. So this will come down to being able to show that they've put in place the necessary protections, be that the appropriate technical and organisational measures that are required. As I've said, that can be IT systems, but also staff training, staff policies, and also demonstrating that they've obtained consent in the right way. There's a new concept of protection by design and default. So that is, when you're putting in place systems or thinking about new procedures, you have to think about data protection and privacy and implement those thoughts into the new designs or the new structures that you're putting in place. And there will be certain circumstances where you need to do a data protection impact assessment, essentially a risk assessment for data and how are these new policies, procedures or systems going to affect data protection. As with data processors, there may be a requirement to put in place an independent data protection officer, and that will be an independent position that needs to be filled. Can be filled by an employee, but their role as the DPO will be independent of their employment. The changes to consent are grabbing headlines as well, particularly amongst marketing departments. They are essentially based on the previous regime, but there's a few additional steps that need to be taken to make sure that you can demonstrate that you've got true consent. So, as a recap, consent has got to be freely given. It's got to be specific and informed. The GDPR has a requirement that it's an unambiguous indication of your wishes for the data to be processed. And also it's got to be done by a statement or a clear affirmative action. So what this means is that because you've got to demonstrate consent, you've got to think about each of those areas to make sure that you are compliant. Because consent has got to be freely given, it means that conditional consent, that is, we will only perform a service, or we will only enter you into a prize draw, or we will only do X, Y or Z if you give us consent. It's probably going to be limited in scope as to how that can be used. It's got to be specific. So it's no good just having a consent form that says you consent that we may use your personal data, or we may pass your data to third parties. It's got to be a lot clearer to give that informed consent. Who are you passing the data to? How are you using it? And an unambiguous indication of wishes. What we're seeing on that is the guidance from the ICO is where there is written consent, it should be clearly distinguishable from other terms and conditions. So you can't have some small print in the terms and conditions regarding the consent to process personal data. It should really be in a separate text box with a separate signature. And carrying over from the current legislation is the right to withdraw consent at any time. So if a data subject is given consent, they should be able to withdraw it, and that has to be done as easily as it was to give the consent. Now the key point with consent is that it can be withdrawn at any time. So for a lot of businesses, it's also worth considering the other grounds for processing data, because consent isn't necessarily the best one. And the other grounds are performance of a contract or the moments before you enter into a contract. So if you're entering into a contract with an individual, then you don't need consent to have their name. You don't need to have consent to have their address. If you're going to be posting goods out to them, you don't need consent if you are sending the goods out and need to pass the address to a courier. Another ground is compliance with a legal obligation. So if you're under a duty to do something, then it's only right that you have the ability to use that personal data in that manner and not have consent that can be withdrawn. There are other grounds regarding protection of vital interests of the data subject or another person, so health reasons, if there is a good health reason and really it's life-threatening or very serious health indications, that you can share or use that data. For public authorities, there is grounds where it is the carrying out of a public interest task or an official authority. But the key thing for most businesses is going to be the legitimate interest grounds. And that is where you have a legitimate interest to process the personal data, then that will be sufficient and you don't need consent. Now, it won't apply where the rights and freedoms of the individual override the legitimate interest because they are considered to be fundamental. But it will cover an awful lot of things. So let's take an employment relationship as an example. Where you are an employer, you've got a legitimate interest to keep records and data about your staff and have that recorded without needing the employee's consent that you record it in that manner. The rights of data subjects are being enhanced under the GDPR. And the starting point on this is the information notices that are given at the time when the data is collected or when it's obtained. And that revolves around telling the data subject what personal data you are going to be holding, how you're going to use it, and what protections are in place regarding that individual's personal data. The next change is to subject access requests. Now, you should be familiar with these. This is the right of an individual to request information on the data held by an organisation about that individual. The changes on this are that the timescales for preparing it are being reduced from 40 days to 30 days and also no longer able to charge a £10 fee. Now, we are seeing an increased use of subject access requests, and I think this will continue once the GDPR comes into play. So it will be very, very important that businesses and organisations make sure they are able to deal with the requests in an efficient manner so that they can ensure compliance. The other changes are very sensible, really. There's a right to rectification. So the ability for a data subject to go to an organisation and get them to update the information with the correct data. There's a right to erasure, or a right to be forgotten as it's known. So you can go to an organisation and say, please remove me, remove all my personal data. Now, that won't override other lawful grounds. So it won't override a legitimate interest point. But in certain circumstances, an individual will be able to turn around and say, delete my personal data. And so your organisation needs to be able to make sure that it can do that. And that may come about by simply just knowing what have you got and where is it. There's a right to portability. So that is the ability to say to a data controller, I'd like a copy of the information and I'd like it going to a third party in an electronic format, in a format that is usable by them. And the final one is a right to a restriction on processing, or a freeze on processing. And that will tend to apply when there's requests for amendments or deletion, and while we're waiting for that to happen, that the data is effectively frozen and not used while the other request takes place. The GDPR is also going to introduce mandatory notification and reporting of breaches to supervisory authorities. So in the case of the UK, the Information Commissioner's Office. Now, that is a new concept. In the past, you didn't have to report breaches. However, if you didn't report a breach and it was subsequently investigated, then the ITO would take quite a dim view of that. Under the new rules, it has to be reported unless it's unlikely to result in a risk to the rights and freedoms of the data subjects. And that reporting has got to be done without undue delay, and in any event within 72 hours unless there's exceptional circumstances. Now that 72-hour period doesn't take into effect business days, so a Friday afternoon breach would need reporting by a Monday afternoon. So for organisations, one of the key things is going to be spotting breaches and also passing that information along to the relevant people within the organisation so that they can make the decision as to whether it is a reportable breach or not, to ensure that it is reported within those 72 hours if required. Even if a breach isn't required to be notified to the ICO, they are required to be recorded and documented, and so again it's having in place the policies and procedures to log all data protection breaches that take place within the organisation. The other big change is going to be a mandatory reporting of data breaches to the data subject themselves, and that's where there is a high risk to the rights and freedoms of the individual. So this could be where health records are lost or financial records are disclosed either accidentally or unlawfully, and it's the requirement to let the individuals know that you've breached data protection requirements in respect of their data. Now that is going to have quite an effect on the reputation of an organisation if they have to do that. The potential fines are the things that are grabbing the headlines with respect to the GDPR, and that's because they've been increased from £500,000 to a maximum of €20 million, or 4% of the total global turnover of the organisation. And when we're talking about the organisation, it's the global organisation as opposed to a particular legal entity. So Apple UK becomes Apple globally, and 4% of turnover could be quite a huge number. Now the ICO have been very clear that it's not going to be a proportionate increase, so just because somebody was towards the top end of the fines under the current regime doesn't mean they'll be towards the top end of the fines under the future regime, and likewise we're not going to have a 40 times increase in all fines, but clearly the much larger fines are going to be used as a deterrent, and we'll have to wait and see at the level of fines issued under the GDPR as to how they compare to current levels. The other risks that an organisation faces around non-compliance are the reputational damage. So if your organisation is found to breach data protection and data privacy, then the damage to it can not only be by customers deciding that they're no longer going to use you, share prices going down, but also perhaps suppliers not being willing to use you because they are concerned about the protection of their data and how you're going to deal with it. So the reputational damage side of things is clearly going to be quite important. And the other element that we are going to see, I would expect, is where data subjects and the individuals are seeking compensation. So they're then able to go to the data controller or the data processor and seek compensation and damages for any losses that they've suffered as a result of the breach. And I suspect that we will see this become a new PPI, or where there's blame, there's a claim type litigation. So that's a brief look at the changes that are being implemented by the GDPR, and we'll be doing some more videos and producing articles on some of those specific points at a later date. But how can Nathans help you with GDPR and the journey that most businesses are going through? Well, the starting point is that we can advise on the law itself. We've got considerable experience on data protection and how that affects different elements of your business. So from a technology side, to also HR teams and employment law issues. We can advise on the contractual documents that you're using. So that might be documents with and agreements with suppliers, with customers and with employees, to make sure that they cover your organisation's risks, to make sure that you're putting the right obligations on people to handle your data, and also ensure that you are able to handle third-party data in the correct manner. We offer a number of different training sessions and workshops, so we can train your staff or train your trainers to spot personal data and conduct information audits, to dealing with subject access requests, or generally in a commercial contracting side of things. We also offer training to HR staff as part of our HR3 offering, and we can also cover GDPR side of things in that, so that HR teams are aware of the obligations that are on them. Should the worst thing happen and you suffer a breach and are investigated by the ICO, of course we can also assist you through that process.